everyone. My name is Brian Awunda, and I am the court assistant for this session. Welcome to the fifth preliminary round of the Greenlaw Global Initiative Climate Justice International Moot Court Competition 2026. The matter before this honorable court is between Herbert Chitepo, School of Law from the Great Zimbabwe University, representing Azania, versus Jomo Kenyatta University of Agriculture and Technology, representing SECA. The honorable bench for this session consists of Lady Justice Helen Omondi, presiding judge, Justice Antoinette Gange, and Justice Cynthia Odongo. I now respectfully invite the honorable judges to take the bench. The court is now in session. Participants, counsels, please note you have 30 minutes for your submissions and 10 minutes each for rebuttals. I will gently nudge and remind you when your time is up. The court is now in session. I respectfully hand over the proceedings to the honorable presiding judge. Welcome, presiding judge.
Thank you very much, Dr. Brian Awunda, and a very good afternoon, good evening to you all. We will go straight into the matter, and it is indicated Henry Chitepo Law School, University of Zimbabwe is for Azania Council. You will indicate how you have arranged or planned to make your submissions. Please begin.
Am I visible and audible enough?
Yes, you are visible. You are also audible.
Thank you. Thank you, Your Excellencies. May it please this honorable court, Your Excellencies. It is indeed a pleasant honor to appear before you today. My name is Michelle Dluayo, counsel for Azania, and with me is my co-counsel, Mr. Monitor Monsaka. Your Excellencies, we have been allocated 30 minutes. In the next 15 minutes as lead counsel, I'll address the court on jurisdiction, the merits issue 1, 2, 3 subsequently, while my co-counsel will address the court from issue 4 to 6 subsequently, and then tender our prayer utilizing 15 minutes. With the permission of the court, I'll love to proceed. Your Excellencies, we appear before this honorable court in terms of Article 65(1) of the ICJ statute, as read with Article 96 of the UN Charter, which empowers the UN General Assembly to request an advisory opinion from the ICJ on any legal questions, which is the reason why we have come before this honorable court today. Therefore, we submit that this court has the requisite jurisdiction to preside over this matter. With the permission of the court, I'll love to proceed. Your Excellencies, we have gathered today to address the defining dilemma of international law, the reconciliation of global trade with the urgent duty to prevent environmental collapse. For decades, Azania has been a destination for second-hand apparel. But following this honorable court's authoritative guidance in its advisory opinion, Azania enacted the Textile Waste Control Act to that effect. Now, as the counsels for Azania, our task today is to demonstrate that Azania's actions were a good faith fulfillment of its positive obligation to protect human rights and the future generations. Now, this leads me to issue number 1. Your Excellencies, indeed, the ICJ 2025 advisory opinion did not merely offer an opinion or a suggestion, but rather it affirmed that states have a positive obligation to regulate transboundary value chains that contribute to climate change. The foundational principle of due diligence was first articulated in the Corfu Channel case, where the court highlighted that no state may be permitted to use its territory may permit the use of its territory to cause transboundary harm. And this position was further propounded or reiterated in the Trails-Milter case. In the same light, Your Excellencies, Azania has an unwavering duty to ensure that activities within its jurisdiction do not cause transboundary harm. When apparel value chains result in a dumping of toxic waste on foreign shores, the no harm rule is therefore triggered, thereby necessitating proactive state intervention. And in this particular case, it is reflective in the enactment of the Textile Waste Control Act. Secondly, we submit that human rights also serve as a driver of this obligation. Article 24 of the African Charter on Human and People's Rights guarantees the right to a general satisfactory environment. Now, with 45% of textile import arriving as unsaleable waste, at this point, it is no longer just a theoretical trade issue, but rather it is an active violation of the right to life as well as the rights to health for coastal communities and future generations. I'd love to direct the court to the Uganda Foundation versus the Netherlands case, where the court also highlighted that national governments should increase their climate ambitions based on human rights obligations. We therefore submit that the Textile Waste Control Act is Azania's chosen proportionate mechanism to fulfill these positive duties, balancing environmental necessity with economic realities. Now moving to issue number 2. Your Excellencies, Azania contends that its conduct prior to the enactment of the Textile Waste Control Act did not constitute to the breach of its obligation of due diligence, because to find otherwise would be to apply the laws of tomorrow to the actions of yesterday. Due diligence is not an obligation, it is an obligation of conduct, not an obligation of result. And this was established in the Serbia versus the Bosnia versus Serbia case, where the state, where it was stated that a state does not breach its duty simply because harm occurred. Liability only arises if a state manifestly fails to take reasonable measures within its powers. Now, prior to 2026, the international community treated the second-hand apparel as a trade commodity, not as a climate vector. In light of this, Azania cannot be faulted for failing to regulate a threat that had not yet been legally or scientifically defined by the international community. Secondly, a state's duty is only triggered when it learns or should have learned of a risk or of a serious risk. Your Excellencies, we submit that Azania did not remain idle upon finding out about the 2025 advisory opinion. Instead, it commissioned the very environmental audits and scientific studies that eventually informed the Textile Waste Control Act. Following the good faith standards established or recognized in the International Tribunal on the Law of the Sea, in the Seabed Advisory Opinion of 2011, Azania acted with due dispatch the moment the 2025 advisory opinion was provided the necessary legal clarity. Lastly, in the pulp mills case, the court held that the content of due diligence must be determined in light of the capabilities of the states concerned. As a lower income state, Azania operates under significant resource constraints. To hold Azania to the same regulatory standards as high income states such as the global north would be to ignore the principle of common but differentiated responsibilities as provided for in Principle 7 of the Rio Declaration. Therefore, we implore this honorable court to measure Azania's due diligence against the tools and the knowledge available to them at the time. And furthermore, the reason why we are here today is because Azania took lead once the law evolved, and it should not be punished for the period before the evolution was even completed. Now I'll move on to my third issue and also my last issue. Your Excellencies, we humbly submit that the measures adopted by the Textile Waste Control Act are fully justified under environmental, human rights, as well as international trade exceptions in international law. Azania is not restricting trade, but rather regulating vectors of harm. The Textile Waste Control Act meets the necessity test of the international trade law. We'll have to give reference to the GATT Article XX, B, and G, where states have the sovereign right to adopt measures necessary to protect human rights and conserve exhaustible resources. We would also love to direct the court to the WTO Appellate Body's obiter dictum in the Brazil retreated tires case, where it was stated that a measure is necessary if it brings a material contribution to public health goals. So now, Your Excellencies, when 45% of imports are not clothing, but rather hazardous wastes polluting exhaustible coastal waters, then regulation at this point is not a choice, but a survival mandate. While we also understand that SECA may argue that the digital traceability requirements are discriminatory towards informal economic actors or small operators. To this, Your Excellencies, we humbly submit that the traceability is the only way to stop the 45% waste ratio. It is a proportionate price for environmental survival. The discrimination is not against informal sectors, but rather it is a distinction between legitimate commerce and environmental dumping. Now, in the total shrimp case, the US enacted laws that require turtle excluder devices to protect sea turtles. Likewise, in this present case, the digital traceability is a standard of conduct applied to all states to ensure the environmental integrity of the product at hand. Lastly, we submit that the Textile Waste Control Act was a proportionate measure because under international law, as seen in the turtle shrimp case, the Corfu Channel case, and the Charles Melter case, a measure is proportionate if there is no less restrictive alternative that achieves the same level of protection. For Azania, no lighter measure can stop microplastic pollution currently choking the marine ecosystems. Therefore, the administrative burden of digital tracking is a small proportionate price to pay to protect the fundamental right to a healthy environment. So, in closing, Your Excellencies, we submit that Azania has not closed its borders to traders or to trade, but rather it is closing the doors to catastrophe. We ask this honorable court to affirm that the state's duty to protect the future generation is the highest obligation of them all. And this marks the end of my submissions. If I may not be of assistance to this honorable court, I'd love to defer proceedings to my co-counsel. May it please this honorable court.
Thank you very much, Counsel. I will inquire from my colleague judges if they have any issues they'd want you to address. Justice Antoinette Ogange, any issues that you'd want Counsel to respond to?
None, Presiding Judge. Thank you.
Thank you. Justice Cindy?
None from me, Presiding Judge.
Thank you. Your colleague counsel may then address us. Please proceed.
May it please this honorable court, as already indicated, my name is Monitor Munsaka, co-counsel representing Azania in this matter. I'm going to deal with issues 4 to 6 and then deal with the issue of tendering in our prayer. May it please this honorable court. Should there be no inquiries from the bench, I would like to proceed to dealing with issue number 4.
Please proceed, counsel.
As the court pleases. On issue number 4 as to whether digital traceability and EPR requirements constitutes lawful regulation or unlawful discrimination. Our position to that issue is that the digital traceability and EPR requirements are a lawful, non-discriminatory and necessary legal requirements or legal frameworks that actually meet climate obligations. And our position is affirmed by the International Court of Justice, advised at Opinion 2025, which provides that states have got a duty of due diligence, which includes regulations of private actors. Now, when we examine the statement of facts, we realize that these measures, they apply equally to all importers. They are also neutral. And also they serve as a legitimate environmental objective, Your Excellencies. One cannot blame the ruler if they don't measure up. In this case, the digital traceability and EPR requirements are the ruler. Now, anyone or any stakeholder who doesn't measure up to that standard, the problem is not the ruler. The problem is either him or herself. In the case of EC Asbestos 2001, the World Trade Organization appellant body confirmed that states may adopt measures necessary to protect human health, even if trade restrictive. Emphasis is mine in that regard. Now, it actually upheld the France ban on asbestos. Let me go through the brief facts about the case. France banned the importation, sale, and manufacture of asbestos on the backdrop that it was actually a health risk because it caused disease like lung cancer and some other related disease. Now, Canada, as a major producer of asbestos, they actually had to oppose the ban because they were not in line with the GATT articles in terms of the standards and the requirements. But now the World Trade Organization upheld France's ban, and the ratio decidendi in that matter was that it was necessary to protect human, animal, or plant life or health. Now, digital traceability and EPR requirements ensures accountability across transboundary supply chains. Now, the opposing counsel may come in and bring in the issue of proportionality test. Now, we are inclined to the positivist approach when it comes to the law. The positivist affirms that law is law, regardless of its moral content, whether just or unjust, because it applies universally and equal to everyone, as affirmed by Thomas Hobbes. So now the issue of proportionality tests, therefore, cannot arise in this regard. Therefore, Azania's TWCEA constitute a legitimate exercise of regulatory sovereignty, which is actually in sync with international law. Your Excellencies, may I proceed now to deal with issue number 5, as to whether exposure to apparel-related pollution violates human rights and intergenerational equity. Now, Azania's position with reference to this issue is that exposure to apparel-related pollution violates human rights and intergenerational equity. Now, failure to regulate textile waste constitute a violation of human rights. Now, in the case of Serac versus Nigeria, the African Commission held that environmental degradation violate, number one, the right to life. Number two, the right to a satisfactory environment. And this can be affirmed by Article 24 of the African Charter of Human and People's Rights. Similarly, in the Agenda versus Netherlands 2019, the Dutch Supreme Court affirmed that states have a positive obligation to prevent harm under human rights law. Now, the ICJ 2025 affirms that there must be protection of future generations through recognition of intergenerational equity. Now, the scientific evidence presented in the Azanian's parliament, it shows that there is black carbon toxic emissions. There's also microplastic pollution in Azanian's marine environment. And also the waste are causing flooding and waterborne diseases in informal settlements. This actually affects children and coastal communities. And therefore, if we make reference to the Pakistan case, whose brief facts I am going to go through for the benefit of the court. Now, there was a petition by mine workers and the general residents against the granting of mining licenses to mining companies, because actually the mining activities would pollute the water, which was actually scarce in the area called Keura area catchment area. Now, the ruling of the court was that there must be a right to have unpolluted water is equivalent to the right of life itself. Then the order was that the licensing authorities must implement strict safeguards, including the restriction of mining activities in the catchment area. Now, with reference to Article 24 of the African Charter of Human and People's Rights, 1981, all people shall have the right to a general satisfactory environment favorable to their development. Now, the United Nations Conference on Environment and Declaration, 1992, Rio Declaration Principle 1 is a declaration in these terms, and I'm going to take them verbatim. It says, human beings are at the center of concern for sustainable development. They are entitled to a healthy and productive life in harmony with nature, close quote. Your Excellencies, what seems to be coming out from these citations that we are presenting before this honorable court is that the right to life is being given an expansive definition, because the right to unpolluted water is equivalent to the right to life itself. All what Azania is doing through the TWCCEA is to promote a sustainable development. And sustainable development was clearly defined by the World Commission on Environment and Development of 1987. This is what it says. Sustainable development is that which meets the needs of the present without compromising the ability of future generations to meet their own, close quote. Therefore, it is our submission that continued exposure to apparel-related pollution does violate human rights, obligations, and intergenerational equity. With the permission of the court, I'll then move to the last issue, which is issue number 6.
Please proceed.
Thank you. It says whether secular economy, social enterprise are legitimate governance actors. Azania agrees that social enterprises are legitimate government actors, but maintains that they are only complementary, not determinative. In other words, they don't offer solutions. That is our position. Now, in the Barcelona traction case, where it was Belgium versus Spain, this very court, in its 1970 judgment, affirmed that primary responsibilities lie with the state. Therefore, social enterprises' role is to fill in the gaps in services that government cannot reach, especially insofar as issues of public health and social welfare are concerned. They function within established legal and market frameworks rather than replacing them. Therefore, Azania argues that many informal actors operate without accountability. Therefore, regulation is necessary to ensure standards as well as prevention of harm. Therefore, recognition under the TWCEA already includes certification and partnership frameworks. So this is to say, social enterprises are recognized but must operate within the state's regulated systems. So that will be our submission in terms of issue number 6. With permission of this honorable court, I will then proceed to tender in our prayer.
Council note, you have 7 minutes.
Thank you. Now, our prayer goes like, the court should find that the TWCEA is a lawful exercise of its sovereign rights and duties under international and human rights law, constituting a necessary, proportionate, and non-discriminatory response to a transboundary environmental crisis, respectively submitted. Thank you.
Thank you very much, Council. Judge Cindy Odongo, do you have any issues you'd want Council to respond to?
None, presiding judge.
Thank you. Judge Antoinette Ogange.
Thank you, presiding judge. Council, I note that you seem to have largely taken a positivist approach to the issue that is before this court. So the court wants to hear your view. Are you saying that the court should completely disregard the practical realities that emanate from the actions or inactions of Azania?
Much obliged to answer the question, presiding judge. Now, my answer to that is our position is that the requirements that we are proposed or that we are highlighting actually is not necessarily a ban completely of the secular economy actors, but it's a matter of providing some legal frameworks within which they have to operate. In other words, we're encouraging these actors to actually follow the laid down procedures and requirements so that at the end of the day, there is a standardized approach in terms of combating whatever issues that actually is a threat to health, like the issue of transboundary harm that might be brought forth by the importation of these second-hand apparel. So that is basically our position. It's not to say we must disregard the effort that comes from the coalition to request or to solicit for some lenience. But we are saying when a country has put up a law, let's be obedient to that law because it's actually for the benefit of the entire nation. That would be my response to the question, Madam Judge.
Thank you for your response. Thank you, presiding judge.
Thank you very much, Judge. Right. Thank you, Council. We will then proceed to hear the position taken by Council for SECA.
Thank you, Your Excellency.
Sorry. Okay. Thank you. Just proceed.
Thank you so much. Before I proceed, could you please confirm whether I can be seen and I'm audible at the same time?
Yes, Council, you are audible and you are visible.
Thank you so much. Thank you so much for that, Your Excellency. For record, my name is Kamara Castro Ouma, appearing with my co-counsel, Mr. Carrera Levis Ndegwa. We are from Jomo Kenyatta University of Agriculture and Technology, appearing for the Coalition for Ethical Circular Apparels, SECA. During my submissions, I will refer to the coalition as SECA, predominantly in the better part of my submissions. Thank you. I beg to proceed. Wish to proceed on the time allocation? I will take 15 minutes of the 30 minutes allocated graciously by this court to address issue 1, 2, and 3, whereas my co-counsel will proceed with the remaining 15 minutes to address issue 4, 5, and 6. If there is no any clarification from the bench, I beg to proceed.
Please proceed, Council.
Thank you, Your Excellency. Your Excellency, the matter presented before this court today goes beyond environmental protection. It also goes beyond climate change. It goes beyond waste management or trade law. But the question presented before this court is to what extent can the International Court of Justice render an advisory opinion that strikes a balance between protection of environment and also safeguard the trade and commercial interests of vulnerable and also the informal circular economies. I beg to proceed and address the question on jurisdiction. Your Excellency, SECA wishes to concede on the question on jurisdiction that the International Court of Justice, pursuant to Article 65 of the Statute of the ICJ, has the jurisdiction to render advisory opinion. This is similarly clothed by Article 96 of the Statute of the ICJ, which gives the Article 96 of the United Nations Charter, which gives ICJ to render advisory opinions on legal questions. SECA concedes that the matter as presented before the ICJ raises a legal question and therefore it suffices to meet the jurisdiction test. I beg now to proceed and address the question on issue 1. As presented before this court today, issue 1 as presented seeks to address whether the ICJ advisory opinion affirms a positive obligation on states to regulate transboundary value chains, including second-hand apparel trade that contribute to climate change and environmental degradation. Your Excellency, members of the court, SECA indeed concedes that states have obligation to ensure that there is environmental safeguard. And this is clothed by specific principles. 1, the precautionary principle, which requires states to come up with precautionary measures to ensure there is environmental protection. 2, the principle of common concern for mankind, which requires states to ensure that activities within their territories does not cause environmental degradation to other states. And preventive principle, which requires countries to come up with preventive measures that ensures this environmental protection. However, SECA wishes to raise a question. Then to what extent does this obligation strike a balance with economic interest and economic pursuits of the informal circular economies? 1, the obligations conferred to the state must appreciate and they must be within the proportionality and must not be discriminatory. Then this raises a question. Environmental safeguards, environmental protection, environmental principles, protection of the environmental must be struck within a balance that ensures this proportionality. And if there is a test that can be adopted to ensure that interest of different parties is met, then that should be adopted as the interpretation by this court. Your Excellency, it is also good to note that the International Covenant on Economic, Social, and Cultural Rights, and also the Article 15 of the Banjul Charter on the African Charter on Human and People's Rights reiterate and support the environmental, the economic and social interest of states and also of its citizens. Then to this extent now, it remains that a regulation only remains permissible if it meets the proportionality and it is not discriminatory, and as a result, then both parties' interests are protected. We submit the Republic of Tanzania, in fulfilling its obligation by enacting the Impact Act, violated the principles of ensuring there is no discrimination, and similarly failed to adopt a test that could be least restrictive, Your Excellencies. And while advancing my arguments further, I will delve into the question then, what constitutes what is least restrictive in environmental protection and also economic interests. Your Excellency, I beg now to proceed to the second question as presented before this court. The second question presented is on the due diligence. The ICJ in Pulp Mill's case, that is Argentina versus Uruguay, stated that diligence is not an obligation of result, but an obligation of conduct. Then it means that an obligation must be interpreted by the common but differentiated responsibility. The same decision, it was held that due diligence still remains to be anchored in a specific with consideration that it is an evolving standard, and also there is need for the resource and capacity constraint considerations, and there is also shared responsibility among the parties. The ICJ decision under paragraph 200, the ICJ advisory opinion on state obligations on climate change, paragraph 281 to 282, state that there is need to adopt appropriate means in matters due diligence. And two, paragraphs 283 to 286 of the advisory opinion on climate change state that there is need for scientific information. And three, paragraph 290 to 292 requires different capability. Then this begs the question. Republic of Tanzania still remains to be a developing state, that it means it cannot achieve specific considerations and economic pursuits in a rapid way. Then this begs the question, then there is need to ensure that in as much as due diligence is to be considered, then the evolving standards are also put into consideration, and also the resource and capacity constraints of the people of Tanzania is also put into consideration. Your Excellency, we submit that no breach occurred as due diligence remains as held in the Argentina versus Uruguay case, that it is not an obligation of result, but an obligation of conduct. Hence, it means that both parties, both the exporting and importing parties bears responsibility in regard to matters ensuring there is diligence on environmental consideration and also trade pursuits. Your Excellency, I beg to proceed to the third issue presented before the court. The third issue forms core of my argument on whether measures adopted pursuant to the ICJ advisory opinion may justify limitation of trade under environmental human rights exceptions. Your Excellency, the Rio Declaration under Article 12, Principle 12, requires that trade policy measures for environmental purposes should not constitute a means arbitrary or unjustifiable discrimination that are disguised as a restriction on international trade. Your Excellency, the act that is being posed, the Impact Act, it brings an arbitrary way to restrict trade that goes against the WTO principles of trade on the most favored nation approach and also the nation treatment approach. Your Excellencies, Article 20 of GATT puts on exceptions to trade. It put an exemption of public morality. It also put an obligation on environmental pursuits. But still, the same provisions adopt that there is need to ensure this justiciability, but also non-discrimination in imposition and also restriction to climate, to trade matters when complying to climate issues. Your Excellency, we invite the court to adopt specific tests to ensure that the interest of the informal circular economy is also protected. But still, before I proceed further, just to remind the court that the advisory opinion that is to be rendered today, its impact goes beyond the Republic of Azania. It touches at Ghana, touches at Guatemala, goes to Brazil, touches on Asian countries that still remains to be developing states. Then how can we strike a balance that ensures that interest of both parties is protected, but also protect the economic and social interest of the communities, the informal, the vulnerable, the marginalized, to ensure that they also have their economic and social rights protected under international law? Your Excellency, I wait to anchor my arguments on the case of Brazil tire case, whereby it was held that environmental and public health objectives justify trade restriction under, but they should be necessary. This still falls within the test that there is need to ensure there is necessity. Has the Republic of Azania met the necessity test? Then it raises the answer, no, it has not met the necessity test. Then it also raises the same question, are these restrictions justifiable? Your Excellency, the restrictions are not justifiable since they remain discriminatory and they are not proportionate to the international trade law principles, and also they do not harmonize the interpretation of international environmental law as well as international trade law. But also to remind us of the advisory opinion that has been heavily relied on by the Republic of Azania. The 2025 advisory opinion that was rendered by the ICJ on state obligations on climate change. The specific advisory opinion clearly noted that it should not be with prejudice to other international laws. Then it means, is this court going to adopt an interpretation that is going to be prejudicial to international trade? Is it going to adopt an interpretation that is going to be prejudicial to the economic interest of the circular economies? Your Excellencies, I submit on behalf of SECA that there exist least restrictive ways in which regulation and environmental safeguards can be met. As submitted earlier on, we don't dispute or we don't argue against the fact that there is need for environmental protection. But still, how do we harmonize interpretation that protect interest of both parties? How do we protect both conflicting parties, but ensuring that we don't elevate international environmental law to the expense of international trade law? And does it mean that this advisory opinion that is to be rendered by this court is going to declare environmental safeguards to be elevative to international trade? Your Excellencies, we submit that the Republic of Azania can achieve the least restrictive ways of ensuring there is environmental compliance. And one of the ways to ensure that this is achieved is ensure there is pre-shipment certification. And this is something that ought to be done as to ensure that both conflicting interests of parties is met. And two, there is reconciliation of interest. And also there is the need to ensure that the state conducts pre-shipment inspection that ensures protection of different conflicting interests is also put into consideration. Your Excellencies, as I wind up on my submissions on the issue, I would like to remind us that this is an informal economy. This is a developing state. This is a state that if these measures are adopted, then it means 2.5 livelihoods are not going to be balanced. then it means that we are going to sacrifice 2.5 million livelihoods, not only in Azania, but also in other states that also will be relying on this advisory opinion. To this extent, I invite this court that while rendering an advisory opinion, to try to strike a balance that brings harmonization between the conflicting parties, between the conflicting areas of law, between international environmental law, international climate change and adaptation law, as well as international trade law. And its decision should also be advised by the GATT Article 20, as well as Principle 12 of the Rio Declaration. Thank you for your time, Your Excellencies.
Thank you, Council. Judge Cindy Odongo, any issues you'd want Council to respond to?
None from me, Presiding Judge.
Judge Antoinette Ogange?
None, Presiding Judge. Thank you.
Council, for me, I would just want you to clarify on one issue. You mentioned something about the least restrictive environmental protection versus economic interest. Would you like to expand a little on that? Should one be sacrificed at the expense of the other?
Thank you for your question, Your Excellency. In my argument on least restrictive, we submit that environmental protection, environmental safeguard still remains to be necessary. However, as was adopted in the Brazil tires case, there is necessity to ensure that alternative measures are less trade restrictive, to ensure that there is consideration and there is harmonization of interest. And in my submission, I submit that no interest outweighs the other. It is about the court adopting an advisory opinion that protects interest of both conflicting parties, but also ensuring and also asking the question, are there alternative ways to protect the economic considerations of 2.5 million people of Azania that depend on this? And one of the alternative measures that we consider to be least restrictive before the enactment of this Impact Act is there is need for government to also put the pre-shipment inspection before coming with this act that is not proportionate and remains discriminatory to the 2.5 million informal circular economies. And also there is need to also bring about certification schemes for the exporters. This ensure that there is burden, there is compliance, and also there is shared responsibility. Your Excellency, I humbly submit.
Thank you. Thank you, Council.
Thank you for your time, and I beg to invite my co-counsel to submit on the remaining issues. Thank you.
May it please this honorable court. My name is Karera Levis Ndegwa. I'd like to first of all kindly get acknowledgement from the bench whether I'm audible and whether as well I am quite visible.
Yes, Council, to both inquiries, yes, yes.
Much obliged. I intend to take on issue number 4, 5, and 6. And I'd like to begin with issue number 4, which is whether digital traceability and the APR requirements constitute lawful regulatory measures or unlawful discrimination against informal economic actors. Honorable members of this court, I'd like to begin by giving a short story. It is a story that is propagated by the late Professor Wangari Maathai, who is a well-known environmentalist from Kenya. She gave the story of the hummingbird, whereby a forest was burning, and it was the hummingbird that took it upon itself to use its tiny beak to take water from the river and try to put out this particular fire and save the forest. Azania is in fact burning, and our continent is in fact burning. However, today we stand before you to represent the hummingbird in this particular case. The hummingbird in this particular case are the members and are the business operators in the apparel industry. First of all, it is important to understand what digital traceability includes and involves to see whether it is practical or constitutes discrimination. Digital traceability includes the tracking of materials and products through the supply chain. It includes creating a verifiable end-to-end record of items history. It includes taking care and ensuring that you can track these products from the source all the way to its destination. These are all activities that do require money. These are all activities that require more than the hummingbird's beak. Extended producer responsibility is another mandate that has been implemented, that has been placed on this informal sector. The extended producer responsibility will require the producers cover the cost of collection, cover the cost of recycling and disposal. This shifts the financial and physical responsibility for managing the product waste from the government to the producers. Producers who lack finances, producers who lack labor to actually be able to undertake these measures. The result of this will be that 2.5 million people will likely be rendered jobless. The result of this will further be that the profession will be left to the few who are able, while the rest of the population suffers. This requirement is a discrimination under Article 2 of the African Charter on Human and People's Rights, and further Article 26 of the ICCPR that mandates non-discrimination. These laws demand equal protection. The 2.5 million people in this case, honorable members, they do in fact pay taxes. And thus it is the mandate of the government to create a kitty to push on this particular sector. The government, honorable members of this court, cannot argue in any way, shape or form that there is no money to push on these particular traders, as Article 9 of the Paris Agreement and Article 11 of the UNFCCC mandates that developed countries provide financial assistance to developing countries. This is part of the principle of common but differentiated responsibilities. Organizations such as Global Environment Facility, organizations such as the Green Climate Fund exist for this particular reason, for mitigation purposes and for adaptation purposes. The United Nations Guiding Principles on Business and Human Rights of 2011 recognize the state's duty to protect and the corporate responsibility to respect rights, but it calls for supportive and not exclusionary regulation. Thus, the regulation should be supportive in the sense that they should be aiming to support members of this informal sector rather than excluding them. Finally, it violates the principle of inclusive sustainability. Sustainability initiatives should be implemented in a way that is equitable to all segments of society. We will further invoke Sustainable Development Goal number 8 that speaks to promotion of decent work for all. These 2.5 million people, honorable members of this court, are in fact doing decent work. And it is the government's mandate as mandated by the United Nations Sustainable Development Goals to ensure that this decent work is protected and is furthered. I'd like to proceed to issue number 5, honorable members of this court, if that is sufficient. May I proceed?
Please do.
Much obliged. On to issue number 5, which is whether the continued exposure of children and the coastal communities to apparel-related pollution violates international human rights obligations, including intergenerational equity as articulated by the ICJ. Honorable members of this court, as representatives of SECA and as SECA itself, we do not come here with unclean hands. We do not come here further as well with malice. We come here recognizing that we do in fact have a duty to protect the environment. Thus, it is our position that yes, the continued exposure of children and coastal communities to apparel-related pollution does indeed violate international human rights obligations, including intergenerational equity as articulated by the ICJ. Article 5 of the African Charter on Rights and Welfare of the Child provides for the inherent right to life of the child. The waterborne diseases in informal settlements and the black carbon and toxic emissions will in fact lead to the harm to the health of these children and further to the destruction of these children's lives. Further, Article 14, Sub-Article 2C of the African Charter on the Rights and Welfare of the Child provides for safe drinking water. These waterborne diseases are being brought about by polluted and contaminated water. Thus, the unchecking of this particular pollution will lead to the violation of this right. Article 24 of the United Nations Convention on the Rights of the Child provide for the right to the highest attainable standard of health. Honorable members of this court, this pollution will see to it that the highest possible attainable standard of health is not achieved for the sake of children and for the sake of members of this particular community. Paragraph 156 of this Honorable Court's advisory opinion that was given last year, specifically paragraph 156, provides that generations are trustees of humanity, trusts with preserving dignity, living conditions, and transmitting them to future generations. As such, we do acknowledge that we do not own the environment, but further, we do actually hold it in trust for future generations, and it is our duty to ensure that it is protected. The unchecked microplastic pollution in Tanzania's marine environment will derail the achievement of intergenerational equity. However, the regulation by Azania should target both domestic handling and transboundary supply chains through international cooperation and not suppression of local livelihood sectors that form part of the circular solution. Let us not just place responsibility on the hummingbird. Let us not just point fingers at the hummingbird, but let us ask questions to the elephants as well. With that being sufficient, I'd like to proceed to issue number 6.
Proceed,
Much
please.
obliged. Much obliged. Issue number 6, which is whether social enterprises operating within circular economy models may function as legitimate governance actors in fulfilling state climate obligations. It is first of all important to acknowledge the meaning of circular economies. Circular economies are regenerative economic systems designed to eliminate waste and pollution. By this very definition, it goes to show that these circular economies are actors in climate governance and not the enemies. It is necessary to involve them. It is necessary to include them so as to be able to actually achieve and eradicate the effects of climate change. Circular economies are different from the take, make, and dispose modules that consume a lot of resources and that lead to the damage of sustainable development. Circular economies, instead, they ensure that there is reuse, they ensure that there is repair, and they do ensure that there is recycling. This is all from the it is from an article published in 2023, March 16th, titled "What is a Circular Economy?" It has been published in Interaction Design Foundation. Further, the European Green Deal of 2020 positions circular economy as central to achieving climate neutrality by 2050. Honorable members of this court, I'd like us to note that much more developed countries compared to Azania have in fact taken it upon themselves, and they have in fact recognized that circular economies are central towards achieving neutrality and towards mitigating the effects of climate change. The European Commission further adopted the Circular Economy Action Plan as part of the Green Deal to reduce emissions from product waste. Honorable members of this court, I'd like to point us to the case that was determined by the African Commission on Human and People's Rights as they delivered a landmark decision in the Center for Minority Rights Development versus Kenya. This has come to be known as the Endorois case. The Commission emphasized on the importance of including local communities in taking care of the environment. These 2.5 million people have been taking care of the environment single-handedly. They have been making sure that apparels that will have otherwise ended up being disposed in the developed countries, which will have in turn created a chain reaction where there will have been need for more production, which leads to more emission. There will have been more emissions arising from the destruction of this apparel. This particular circular economy has ensured that this has not happened. They have ensured that there is reuse, they have ensured that there is recycling, and they have ensured that they are trying, at the level best, with the little bit that they have, as the hummingbirds in this particular case, to bring down the effects of climate change. In the compromise, it is highlighted that despite being a low emitter, Azania are heavily affected by the effects of climate change. This circular economy and these members of this circular economy are trying to put an end to this. They're trying to reach a balance of economic and environmental, to reach a balance of economic and environmental rights. The state ought to, first of all, ensure there is proportional regulation that does not unduly harm legitimate market actors. They, number two, need to recognize and support circular economy initiatives contributing to sustainability. And they finally need to protect human rights and economic rights in parallel with environmental duties. Honorable members of this court, as I conclude, it was Justice Herbert who said almost 100 years ago in the case of R versus Sussex that justice must not just be done, but it must also be seen to be done. Honorable members of this court, I urge you to give direction and to make it clear that it is not just the hummingbirds who should face the burden of responsibility. However, let us as well share the burden and thus bring forth an end to the effects of climate change. If this is sufficient, I'd like to take any questions from the bench if there are any. Much obliged.
Thank you. Thank you, Council. Judge Cindy Odongo, any issues you'd want Council to respond to?
None from me.
Thank you, Judge. Judge Antoinette Ogange, any issues?
None, presiding judge. Thank you.
Okay. Council,
Yes.
just as a matter of curiosity, I like your reference to the hummingbird that Professor Wangari Maathai referred to. But I'm just wondering, wouldn't the legislation that Azania has placed perhaps be the hummingbird? What would you say to that?
Much obliged. I'd say that the legislation in this matter and the responsibility that it has actually put is in fact the water that the hummingbird is trying to fit in its beak.
I think you saw my notes because I'd actually indicated that the legislation was water. But thank you for your response, Council. I think the bench does not have any more questions, and perhaps now it will be for the rebuttal. Maybe the court assistant will guide on the rebuttals, the time assigned for the rebuttals.
Thank you, Presiding Judge. Councils, please note you have 10 minutes for your rebuttals. We shall begin with Herbert Chitepo Law School representing Azania. You're muted. Kindly unmute. You're muted.
Pardon me for that, Your Excellencies. May it please this honorable court, Your Excellencies. I rise once more to briefly address the fundamental misconceptions presented by my learned counsel from representing SECA. Throughout their submissions, they attempted to frame this case as a conflict between trade and development, and this is a false dichotomy. They seek to ask this honorable court to prioritize short-term profits of unregulated global value chains over binding environmental law obligations. They have also characterized Azania's measures as arbitrary, yet they have also failed to provide a single alternative that effectively stops the 45% waste currently suffocating the coastal ecosystems. Your Excellencies, Azania submits that international law is not a suicide pact. We cannot allow trade to become a mandate for transboundary dumping. And thus, we shall specifically address the SECA's failure to address the principle of due diligence and their misinterpretation of the GATT Article XX. Your Excellencies, the GATT Article XX allows states to actually adopt non-discriminatory measures necessary for public policy goals. And these exceptions permit the restrictions that would otherwise violate trade rules, such as protecting human rights, plant and animal life, public morals, and conserving exhaustible natural resources. Most importantly, we submit that the Textile Waste Control Act is a proportionate law because it only targets the most harmful activities. For example, the high emission value chains based on best available science rather than a blanket ban on all trade. In essence, trade is meant to increase standards of living, and this would be impossible in a collapsing climate. Food for thought to the learned colleagues from the SECA. In any case, Your Excellencies, transboundary climate harm causes massive economic stability. The principle of sustainable development is a widely recognized principle in both trade law and also environmental law, which reconciles the economic growth with environmental protection. It also guides policy by meeting present needs without compromising future generations to meet theirs. This marks the end of my rebuttals. With this, may it please the court. If I may not be of further assistance to the court, I would love to defer proceedings to my co-counsel.
May it please this honorable court once again. Honorable members of the bench, I only have two issues that I want to rebut from SECA's presentation. One, they seem to anchor their submission arguing that the TWCCEA is actually excluding the circular economy. Our answer to that is that regulation is not exclusion. When you regulate, we're actually promoting standards. We want things to be done according to a certain standard so that we avoid certain things like the disease which can actually come through unregulated economic activity, which SECA happens to be standing for. So that's basically issue number one. Then the last one, of course, will be, it seems Council for SECA, especially the second council, seems to be making an interesting departure from his original position, because he is bringing issues of human rights, which is actually a strength to our party, which is Azania, which we represent, because there are two issues that we need to address here. Azania stands for the promotion of human rights, whereas SECA is standing for economic rights. So there is no way you can talk about economic rights before you talk about human rights. There is no economy that you can talk about before you talk about someone who is alive. In other words, human rights have to come first before we consider economic rights. So in other words, this is our position to say we prefer that there must be upholding of human rights first, and then economic rights can come forth. So the argument by SECA now seems to tilt that position to say, let's consider economic rights before we consider human rights. It doesn't work like that. So basically that is our position, and that will be my rebuttal. Thank you. May it please this honorable court.
Thank you, Counsel. Judge Cindy Odongo, anything you'd want counsel to respond to in that rebuttal?
None, presiding judge.
Thank you. Judge Antoinette Ogange?
None, presiding judge. Thank you.
And I do not have any issues either, counsel. Thank you very much.
I please the court.
We will then hear from counsel for SECA on the rebuttals.
Thank you so much, Your Excellency, for allowing me to appear again on this matter. I beg to rebut. I will take 5 minutes of the 10 minutes to rebut, whereas my colleague will take the remaining 5 minutes to make the rebuttals. Your Excellency, our rebuttal is anchored on the advisory opinion on state obligation on climate change that was rendered in 2025. It is good to note that the advisory opinion did not create exemptions on obligations. Similarly, this advisory opinion does not in any way override the international trade law. To this extent, we still submit that the state of Tanzania has a responsibility in its duty and obligation of protecting the environment to ensure that there is compliance and there is striking balance between conflicting interests. I beg to anchor my rebuttals on three pillars. One, there is a need for trade and environment to be balanced. And this has been established previously in the Rio Declaration, Principle 12, the need for ensuring that in as much as environmental safeguard, there is also protection of interest in international trade. And this is anchored through ensuring that there is no arbitrary or discriminatory measures that to some extent discriminate some parties due to environmental safeguards. To proceed on the second pillar of my argument for rebuttal, Your Excellency, the informal economy is not disposable. And the advisory opinion to be rendered today and the invitation that is being made before this court by the councils appearing for Tanzania is that we have not provided alternative measures. Your Excellency, the interpretation of law must be harmonious. It is good to take into consideration as you retire to render the advisory opinion that did the court, did the ICJ not use the word without prejudice? And does it mean the advisory opinion to be rendered today by this court is going to prejudice international trade law? Does it mean that the advisory opinion to be rendered by this court is going to violate the international trade principles? Your Excellencies, we invite you that this matter goes beyond the Republic of Tanzania. It touches on deep informal economies. It touches on circular economies. And please, as you retire to make a determination on the matter, be guided by the principles and the exceptions created under Article 20 of GATT, and similarly be guided by the Principle 12 of Rio Declaration, which states about environmental matters and striking balance with international trade. Your Excellency, I rest and thank you so much for appearing. Unless there is any clarification from the bench.
Thank you, Counsel. Let's hear from your colleague, and then I'll ask my fellow judges if they have any issues. Please proceed, Counsel.
Much obliged. I'd like to begin this rebuttal by first of all emphasizing that even neutral legislation becomes unlawful where its burden falls disproportionately on vulnerable economic class. Article 2 and Article 3 of the African Charter speaks to equality. Equality under these articles prohibits not only explicit exclusion, but also regulatory architects whose compliance design systematically favors formal capital over informal survival. The absence of number 1, phased implementation, number 2, small trader exceptions, and number 3, establishment of cooperative traceability hubs shows that the state failed to tailor the law. Honorable members of this court, we do in fact rely on human rights, and we do as well rely on economic rights, rights which this honorable court is called to balance. As such, we do not say that either of these rights should be substituted for the favoring of the other. However, when you cancel out some economic rights, you will in fact be leading to the detriment of some human rights, such as the right to life, as if these people do not have any livelihoods, then they will surely suffer. These 2.5 million people are today before this honorable court asking it to try and bring forth and to try and stamp and rubber stamp the economic rights. If this honorable court does not see that this is worthwhile, then tomorrow this 2.5 million people might be before this honorable court asking that this honorable court gives them employment. As such, members of this honorable court, it has been an honor to present before you. I'd like to rest my case unless there is any question.
Thank you, Counsel. I will invite my colleagues to pose any issues they want for clarification from either counsel. Judge Cindy Odongo.
Thank you, Presiding Judge. I have one question for Mr. Carrera.
Yes.
How would you classify human rights vis-a-vis economic rights? Are human rights and economic rights hierarchical, or how would you classify them? If not, how would you classify them?
Much obliged. Human rights can be divided into civil and political rights. They can also be divided into economic and cultural rights. These rights are in fact hierarchical, but in fact the right to life does take precedence over all these other rights. However, that does not mean that some of these rights should be substituted, but further, this honorable court should try and bring a balance while trying to bring the fulfillment and achievement and the enjoyment of all these rights. Is that sufficient?
Thank you.
Much obliged.
Thank you, Judge. Judge Ogange.
And none, Presiding Judge. Thank you.
Thank you. I also have no questions from the rebuttal that has been placed. Thank you very much, Counsel.
Much obliged.
Back to the court assistant.
Thank you very much, Presiding Judge. That marks the end of submissions for both sides. I now respectfully request the honorable judges to retire from the public courtroom and proceed to the chambers for deliberations. To the rest of us, kindly remain on the call as we await the return of the honorable judges for the delivery of their determination. Honorable judges, we can log out from the platform and meet at the chambers. Once again, welcome to the penultimate session of session 5 of Global Initiative Climate Justice Moot Court Competition. This session, as the bench notes, matters court etiquette was 100% from both sides. We really commend you for that. So I'll start with the duty bestowed upon me to give you your individual feedbacks before the court gives its determination. So we'll begin with Herbert Chitepo. Michelle, the bench notes you had a good grasp of the law and you could easily and perfectly apply it to your arguments. The bench also notes that you have good persuasive skills. You have very good court etiquette, as indicated. On your rebuttals, the bench indicates that you are very specific on your rebuttals and on your stand, which was very commendable. The bench also notes you maintained proper eye contact and you exuded confidence. The bench also indicates you had good oratory skills. For your counterpart, Monitor Monsaka, the bench indicates you had very good grasp of international law and legal principles. The court indicates you are very specific and clear in your arguments and in the different heads you are submitting on. The bench indicates you are able to relate case laws to your facts. The bench also indicates you have very good court etiquette. The bench also indicates you had you're very logical in your arguments. You are courteous to the opposing counsel. You are confident, and you had good ability to apply the law. And the bench also noted that your moot court coach, I think he's on the platform, has done a very commendable job in teaching you court etiquette. Right. To counsels for SECA, beginning with Castro, the bench indicates you had good understanding of international law and legal principles. You had proper ability to apply legal principles. You are passionate about your submissions. You're a quick thinker on your feet. You had very good court etiquette as well. The bench also enjoyed listening to you because of your confidence. You understood what you were saying, and you answered your questions well. That was fronted by the bench. As for your counterpart, Carrera Levis, the bench notes you had very good use of legal principles, very good court etiquette. You combined definitions with legal provisions. Just that at some point, your arguments appeared to support the state of Azania, but you amended that at the end. You addressed the court with utmost professionalism. The bench also notes there were some distractions behind or rather on your background which seemed to distract you. You have explained to me why you should look at that. The bench also notes you had a good opening statement and also you are persuasive. You could tie your arguments with the opening statement and reduce a bit of reading. And from my side, I would commend Herbert Chitepo for reference to the Agenda Foundation case, which is the first time I've had this case in this moot court. And it's the first climate litigation petition that held the government, in this case, the government of Netherlands, for having a duty of care to protect its citizens from matters of climate change. So this is a case that other participants need to look at as to front their arguments. With that, I cede back the platform to the presiding judge for determination. Welcome, presiding judge.
Thank you very much, Dr. Brian. So this is the outcome of our conferencing. Having considered the arguments that were presented before us, your knowledge of the law, the application and analysis, depth of legal reasoning, the structure and clarity, especially the logical flow of arguments, as well as the advocacy skills in terms of persuasiveness, in terms of responsiveness to judicial questions, and your use of authorities, especially relevant case law, treaties, and instrument, the outcome is as follows. Herbert Chitepo, Law School, Zimbabwe, 84%. Jomo Kenyatta University of Agriculture and Technology, known as JKUAT, 85%. So JKUAT carries the day by just a mark above the other, 85%, and Herbert Chitepo, 84%. Thank you. It was a great session. Back to you, Court Assistant.
Thank you very much, Presiding Judge and the judges at large. I'd like to point out that this is the session that has scored the highest marks thus far in this moot court competition. And before we log out, there is someone very key on the platform, Madam Freda Kebkabatse, the moot coordinator of Catholic University of Eastern Africa. I'd like you to say hi to the people since two of the judges on the bench passed by your hands at Catholic University, being Judge Antoinette and Judge Cynthia. So just say hi to us and then, yeah.
All right. Thank you so much, Brian. I know we are all very tired and want to retire. Honorable Lady Justice Helen Omondi, Lady Justice Cindy Odongo, and Antoinette Ogange. First, I must say I am very happy that I'm speaking when the bench is an all-lady bench. It really is a pleasure. Justices Antoinette and Cindy were at the Catholic University. Oh, I should maybe say who I am. Frida Kabatsi. I'm the head of Department Public Law, also in charge of moot courts at the university, and I also teach public international law. Yes, so back to our honorable justices. All protocol, of course, observed. I know we have other judges on the call today, but just to say, very proud of Justice Antoinette and Cindy. You know, when you see your students doing great things, it makes this life all worth it. And also to our students, we have our students on call, but specifically to the participants today. Great job, both teams. The things you're adjudicating on, you know, stem from the advisory opinions, the one that was read last year in The Hague, a few weeks before in Costa Rica, the Inter-American Court, and of course a year before in Hamburg at ITLOS. Very, very complex issues you are adjudicating on, and you're assisting us. You are enriching the jurisprudence on international environmental law. And I think that's very important for you to take home. It's a competition. Whoever wins or loses, know you are making a difference. So I think, Brian, that's it. I have shamelessly
Thank you.
say that I'm really proud of Antoinette and Cindy. And also, since you have allowed me to brag, because last year the bar was led by Faith Odhiambo, was also our student, the LSK president. Maura Kabata, her deputy, was from Quer, and the president of the East African Law Society, Ramadan, is also from Quer. So since you have allowed me to, you know, I forgive me for bragging, but thank you so much, Brian, and all the best to the team, all the best to the judges. We're really honored to have you and to learn not only from the students, but also from the bench. Thank you, Brian.
Thank you so much. This marks the second last session of the preliminaries. The last session will be on Wednesday, the 15th of April 2026, between University of Zimbabwe and Uma University from Kenya. With that, I believe the court is functus officio. If there's no other thing from the presiding judge, maybe presiding judge, you could tell them something, because the next time you'll see them is 24th of April. So you could just give them an encouragement and then we close up.
Thank you. Thank you so much, Brian, for this opportunity. This was, these two teams had a very, very professional approach, in-depth arguments. It was actually a task to even grade them because they were almost neck to neck. Well done to the coaches that took them through. You seem to have thought of everything from the developing jurisprudence to just the lived realities that this is not just a moot, but what is actually happening in this continent. And I, as a sitting judge, an actual sitting judge, I'm telling you, I'm learning a lot that I'll even use in my court in making decisions. What you have done is actually done research for me. So I really appreciate what you have done. Thank you so much to each one of you. Thanks a lot, Brian.
You've heard it for yourselves from a sitting Court of Appeal judge. Let me say no more. You're free to leave the platform. Have a good evening. Thank you.
Good evening. Thanks.